Welcome to Oil and Gas. Today we get to talk about a lot of issues that can come up when you are conveying an oil and gas interest. And the first issue we'll talk about is something that we've actually previewed before, which is just making sure you get all that you intended to. And so we're going to talk about the Mother Hubbard clauses as well as coverall and catch-all clauses. And we're going to do that primarily by talking about this case, this J. Hiram Moore versus Greer case. It's on page 575 in your texts. Now, basically what happened in this case was that there was a deed that conveyed royalty interests, but it referenced the wrong survey. And so the grantor didn't actually have any interest in that survey. But the deed also said, in addition, this conveyance also includes all of the grantor's royalty and overriding royalty interest in all oil, gas, and other minerals in the above named county. So all royalties in that county, whether actually or properly described herein or not. And so the question is, well, wait, because the grantor had royalties, just not in the land described. So in one sense, the deed seems to convey nothing because it says, oh, you get this royalty in this property, but you didn't have a royalty in that property. On the other hand, it seems to convey all of her oil and gas interests because it includes, she had several royalties, even including ones that maybe she wasn't intending to transfer in that county, but they all go through this second clause that says you get all my royalty in this county. Okay, so the appellate court analyzed this as a Mother Hubbard clause. And you'll remember the Mother Hubbard clause typically says you get to have the adjoining lands. What had happened is the trial court had granted summary judgment saying that this conveyance included all of the royalty interest in the county, but the appellate court reverses and says, no, Mother Hubbard is only supposed to apply to these small strips that are on the edge of land. So, imagine that your land was actually a pentagon, but what you described was really a square. The Mother Hubbard clause would give you that little extra piece. So the court says it's really only supposed to apply to these small strips that get left out of the property description in a deed. Supreme Court affirms the appellate court, and it doesn't necessarily agree with all of its reasoning, but it says, look, this deed is just ambiguous, so we have to leave it to the jury. And so the trial court was wrong to grant summary judgment. The appellate court was right. You have to leave this to the jury. And the reason the Supreme Court finds it ambiguous is because it at one time seems to convey nothing, and because the specific description of land doesn't actually include a royalty interest, and the other hand seems to give everything in the county. The court in Jones versus Colley, the decision the appellate court had relied on, had said, oh, well, this Mother Hubbard clause is ambiguous if it includes significant property interests. Okay. Now, as a reminder, here's what the Mother Hubbard clause typically looks like. It usually says, this lease also covers and includes any and all lands owned or claimed by the lessor adjacent or contiguous to the land described here and above, whether the same be in said survey or in surveys and adjacent surveys, although not included within the boundaries of the land described above. So as that Jones versus Colley decision, as that appellate court decision seems to suggest, look, this is just for some contiguous land, so it shouldn't really cover everything in the entire county. But if you'll recall, the specific language in this deed actually did say everything in the county. And so one kind of question you might have about this decision is, wait a second, is this a Mother Hubbard clause at all? Maybe it's a catch-all clause, which is another kind of clause that you can use for imprecise descriptions of land. Catch-all clause basically allows you to convey all your interests in some wider area because imagine that your interests are too numerous or small that it just wouldn't be cost effective to describe them all. You're worried you'd make a mistake. So you just say, look, I have everything in this county. And the dissent, which believes that this is really a catch-all clause, goes through a number of reasons that you might want to use that kind of clause. The Mother Hubbard clause is supposed to be, if you have a bad land description. So as I said, maybe it leaves out one point, and so it leaves out a sliver of land. Catch-all clause, maybe that is just more efficient if you're describing a lot of small interests in a county. Title examiners who have to figure out all day what people own in their oil and gas by looking through deeds, they don't like this Moore versus Greer decision because, for one thing, they thought, this is a catch-all clause. This isn't Mother Hubbard. So all the discussion of Mother Hubbard is confusing. Really, Mother Hubbard is just supposed to be for that adjacent and contiguous land. And they now say it's a little bit hard to say whether something is a Mother Hubbard or catch-all clause. You can save yourself a lot of headache, be a little bit clearer up that in front. Is this a Mother Hubbard clause for contiguous land, or is it a catch-all clause? I would encourage you in your own practice to try and be clear between those two concepts, one for adjacent and contiguous land, one for a wider swath of land intended to catch all the interests. I think that you all could have the ambition to be clearer than the courts have been in this case.